Thank you. Thank you very much, Sarah, for paving the way to what I want to say. Let me start by saying that my definition of a pessimist is an informed optimist, and I tend to be subscribing more and more to that. Ladies and gentlemen, thank you to the organizers. I've been a very exotic fruit. I'm not exotic anymore, but very tropical still. A Greek teaching international law in Turkey, specializing on maritime delimitations. So that leads to a disclaimer that if I present the Turkish position in a less than perfect way, then apologies to start with. So interestingly enough, I've been asked to present the Turkish position over all this, and I'll try to do this to the best of my ability. Having said that, I think it would be fragmented to see it only this way. The Turkish position regarding the Eastern Mediterranean is certainly also a position that is interconnected to Turkey's other interests in other areas, the Black Sea, the Aegean, most importantly, and of course the Turkish position on the Law of the Sea Convention. And I'll try to see how this is changing. In the past year or so, I had a huge déjà vu because we were reliving days of 73 research vessels out in the Mediterranean, followed by frigates. And my question was, have we learned nothing in the last 40 years? It's obviously a revival of a situation that was very deplorable to start with. There's a lot of discussion nowadays in Turkey, certainly in Cyprus, of course, and by that I need to make the disclaimer both sides, southern Cyprus and northern Cyprus, to give a geographical definition, certainly in Greece, on exclusive economic zones. And I'd like to differ. I beg to differ slightly to say that I think this discussion is disorienting regarding what is at stake now. What I mean to say is that if it is only hydrocarbons we're after, gas and oil, then continental shelf as a regime is more than enough. We don't really have to have the discussion on exclusive economic zones. The EEZ is a regime that introduces, of course, a wider environment, geographical and otherwise, but it's very clear that there are only three kinds of rights brought by the EEZ in addition to what is offered by the continental shelf. And these are fisheries rights, environmental protection rights, and the potential of exploitation of energy production from the air. That's it. It's an exhaustive list provided by the UNCLOS. So unless we're talking about also fisheries, the production of air through turbines above the sea, or the protection of marine environment, then there's absolutely no need to talk about the EEZ. The continental shelf is more than enough. And the continental shelf is not consumed in the EEZ regime. On the contrary, I would argue that the continental shelf is a much more established institution versus the EEZ, which is a younger and thus more uncertain institution. In this respect, I think that countries which are after hydrocarbons should rather focus on continental shelf delimitations rather than EEZ. And I'm saying this because also in this area, introducing an EEZ means introducing into the discussion other areas, adding to the problematic to start with. If there is a disagreement on continental shelves, then it's only getting worse by adding other areas like fisheries and environmental issues. And on top of that, if you go for delimitation through an international adjudicative organ like the International Court of Justice or a tribunal, then it provides much more leeway for the courts to start balancing out disputes. Now, if you see the jurisprudence of the International Court of Justice that was mentioned before, and administrative tribunals, in 100% of the cases, not 99, 100% of the cases, islands, and by this I mean Cyprus as well, were either disregarded totally or partially regarding the continental shelf rights, and this would only be augmented in the case of exclusive economic zones. So what I submit is that states, like Greece for that matter, that have now a fixation with referring disputes to the International Court of Justice should think twice, because it's not going to be a walk in the park. To connect it to Cyprus, as I said, in 100% of the cases, the rights of islands are diminished. For instance, in a case between Libya and Malta, an island state, very much like Cyprus, was taken for the purpose of the delimitation as part of Italy. So there are no guarantees that the same might not be true again and again. Regarding the possibility of adjudication, we should be rethinking things over. Now, back to the continental shelf. I think that it would be much more to the interest of states to start delimiting areas that already belong to the state, like continental shelf, rather than introducing discussions like the exclusive economic zone. On top of this, continental shelf belongs to the state, as I said, ipso facto and ab initio, by virtue of being a coastal state, whereas the EEZ would have to be proclaimed and delimited in order for the states to start exploration and exploitation activities. There's no question of a unilateral proclamation of an EEZ. Continental shelf is fine. It belongs to the state. The rights are there. If the state wishes to use it or not, it's up to the state. But in the case of exclusive economic zones, it would first have to be proclaimed, and second, it would have to be delimited. The law of the sea convention is absolutely clear that no state can start exploring and exploiting the natural resources in the exclusive economic zone if there is the presence of other littoral states, and delimitation needs to be there beforehand. And this is exactly why the Republic of Cyprus signed agreements with Israel, with Lebanon, with Egypt to this effect. This is exactly why there is no discussion, or there is no substance to the discussion nowadays, for instance in Greece, on a unilateral proclamation of the EEZ and further exploration and exploitation of the natural resources. Unless there is an agreement with Turkey, no discussion can be in place. The same would be true for the northern parts and northwestern parts of the island of Cyprus, if exploration exploitation activities would have to be in place. A note on delimitation then. It's one thing to talk about entitlement in principle of areas, and a very different one to talk about the delimitation of this right. The entitlement of certain geographical features, anything from continental territories to islands, to continental shelves in principle, and to exclusive economic zones, is granted. However, entitlement in principle, the right to generate these zones, and delimitation of these rights are two different things. And it is certain that the International Court of Justice and all tribunals that have adjudicated cases like this have taken this into account. And this is why you see a deviation from the entitlement in principle to rights down to delimitation. This is what equitable circumstances come in to do. The courts start with the right in principle of a geographical area to generate zones, and then they modify this depending on a number of geographical and non-geographical characteristics, from the length of coastlines to historical rights to fisheries, an open-ended list, as Sarah said. So effectively what courts have done to the day is apportionment and not delimitation. In my mind, this has been even illegal, but then again, who am I to say? Special circumstances, in the jargon of the courts, and equity and equitable rights have opened Pandora's box, and anything and everything can be understood as a special circumstance modifying a possible solution. Now, in the case of this area, one thing of the other problems that should be added in the same breath is sovereignty conceptions. All states in the area, and certainly Turkey, Greece, Cyprus, have very rigid conceptions of security. And I would submit that these need to be critically revisited nowadays because of new considerations such as human rights, the global and regional markets, environmental goals, democracy, you name it. If this is the starting point, in other words, rigid conceptualization of sovereignty, we're not going anywhere. And this also contradicts what I would call the social spirit of the convention, which prioritizes agreements, prioritizes common good, prioritizes peaceful settlement of disputes, splitting contested areas, this and that. We can be more specific regarding environmental issues and all, but the point is that rigid conceptions of sovereignty, coupled with very rigid conceptions of the law as it used to be, are absolutely obsolete and out of touch with reality nowadays. Let me summarize briefly, if I may, in 5 minutes? 3? Yeah, 3. The
liberal interpretation.
Yes, obviously, yes. I'll try to deconstruct the stereotypes and fit within the type. Let me briefly summarize, if I may, the official Turkish position for you to have a view, and not that I necessarily subscribe to all of it, of course, and end up with a couple of little suggestions. Firstly, it is very clear that Turkey formally does not accept the right of the Republic of Cyprus to represent in law or in fact the whole island. The Turkey believes that Greek Cypriots are not entitled to negotiate or conclude international agreements and adopt laws regarding the exploration and exploitation of natural resources on behalf of the entire island, because they say that this compromises and prejudges the Turkish Cypriots' inherent rights and as such equal rights. The Turkish Cypriots and Turkey see that the issue should be part of a comprehensive settlement in Cyprus, according to the Annan Plan. You might recall this was left to be decided by the joint parliament. The Turkey says that the Greek Cypriots' unilateral actions also challenge Turkey's maritime jurisdiction areas in the Mediterranean west of the island. If we go back to the maps, we have blocks 1, 4, 6, and 7 to the south and southwest of the island, and further say that in the south the plots overlap with Turkish Cypriot concessions to the Turkish Petroleum Company granted in last September of 2011. The proposal by Turkey is either to leave the issues to the aftermath of a comprehensive settlement, or for the two sides together to bring the issue before the UN Secretary General and determine ad hoc jointly the future of exploration and exploitation. Having said that, Turkey, of course, interprets the law of the sea in a very interesting way. It is not a signatory member. However, of course, it subscribes to it, for instance, the 12-mile territorial seas that already it affects in the Black Sea and in the southeast, and argues that in the jurisprudence, islands, including Cyprus for that matter, have never been granted full effects or in very, very few circumstances. Additionally, Turkey, of course, presents a linkage with the Aegean and the case of the continental shelf in the Aegean, potentially the EEZ as well. Politically speaking, because of the instability in the area, Turkey wishes to have a foot, and thus, again, politically, strategically speaking, it has less of an incentive to delimit things and get out of the way. If you like, on a personal note, I think that because Turkey, because the Cyprus issue has cost Turkey so much, historically, financially, politically, it's about time to get something out of it in the sense of hydrocarbons. Ankara says either share it with Turkish Cypriots or share it with us. You decide. Either you think you represent the whole thing, in which case you come with the Turkish Cypriots and find a sharing agreement, or you don't talk to them but talk to us, because we as a guarantor power are in place, and therefore delimitation should take place between either of you. You decide. Briefly that. I'm not going to go into details because I think Christoph is going to crucify me. Now, and of course, yes. Now, the very, very concrete suggestion for the future. I think this whole discussion is getting out of hand. In principle, if you want to find a solution, and I'm sure you can find a solution, that's not the issue, even in cases whereby there is this, this discussion on non-recognition between the states and all. No, there is precedent. Of course, Greek Cyprus does not recognize Turkey and vice versa, but this has not stopped them from approaching tribunals like the European Court of Human Rights, for instance, together. So if you want to find a solution, you can find a solution. Concrete suggestions. One, start deconstructing the public dialogue. In the respective countries, everybody believes that they're going to become very soon very rich. For instance, in Greece, everyone is convinced that the International Court of Justice is a preferred method. Every widow and orphan in Athens talks about the ICJ in an ecstatic way. And it's not going to be like that. So deconstruct at the public sphere the discussion. Secondly, use the economic crisis as an opportunity and not as a challenge. It reminds me sometimes the situation here of very poor relatives who inherit a piece of property, and rather than all of them getting a chunk out of it and having better lives, decline to do so just for the other not to get anything. So perhaps we can use the economic crisis as an opportunity to put traditional disputes behind and move ahead. This will certainly decrease defense expenditure, which is very much in the interest of countries at the moment, and also it would hopefully lead to cooperation in other fields. Thank you so much.